Johnny, thank you very much indeed. Johnny Diamond there, our royal correspondent. I'm joined by two eminent members of the legal profession. Stephen Laws, QC, who's a former first Parliamentary Counsel, yes. I think I'm right in saying, also from the centre-right Policy Exchange on their Judicial Powers project, and Alex Baylan, QC as well. Well, I mean, just tell us first of all, Alex, what's your reaction to this? Because a lot of people, a lot of legal commentators, they didn't expect a unanimous judgment from the Supreme Court justices.
No, absolutely. It's a magisterial and stinging rebuke for the government. It's a strong reaffirmation of parliamentary democracy. It reaffirms that the executive is accountable to Parliament and that the executive is not above the law.
And what about you, Stephen? Just give us your immediate reaction.
Well, I'm shocked and disappointed, actually, because I thought this was a storm in a teacup, and it turns out that it's blown up the Constitution more or less as we know it by involving the courts in the relationship between government and Parliament. One reason I think that Brexit has proved so difficult is because a relationship between two has been complicated, as relationships between two often are, by the introduction of a third party. It started with the introduction of the referendum result into that relationship. Now the courts have added themselves to this complication, and that makes four. And the relationship between government and Parliament normally works well. The government doesn't do things Parliament will not accept, and Parliament tends to accept what the government leads it to do unless it really objects. You introduce two more parties into it and you get constitutional chaos. And introducing the law is not a good idea into politics either. The law decides things on the basis there is a right answer given to you by a rule. Politics works on the basis that the right answer is the one that commands the widest degree of acceptance from the electorate, and that, to me at least, has always seemed to me a much better way of resolving political questions.
Alex Baylan, where does this leave our unwritten constitution? I mean, the balance of powers between Parliament and the government and the courts.
Well, it actually, if anything, strengthens our constitution. It's often said that we're in trouble because we don't have a written constitution. In fact, this is a strong reaffirmation that the constitution works quite well. It's only constitutional chaos because the government tested these matters to the limits. The courts have respected parliamentary supremacy, have upheld accountability of the executive to Parliament. That is a strong and stable constitution. There's no chaos at all. And we need to end this game of constitutional cat and mouse where cases are going from across the square to here. We need to get on with the business and let Parliament and the people decide what needs to happen.
I just want to show viewers a picture now from Tom Tugendhat, Member of Parliament from the Conservative Party, who's actually sent out a picture of him sitting on the green benches, and there is, as we've heard from the Supreme Court, really nothing to stop members of Parliament sitting in there at the moment, because that prorogation, that suspension of Parliament has been quashed. I mean, the judges here just said, it doesn't exist. Parliament, the prorogation, the suspension of Parliament, it's as if it never happened because it was unlawful.
That's right, and I don't know whether anyone said this to you already, but Standing Order 9 of the House of Commons says it meets at 11:30 on Tuesdays, and just past 11:30.
Right, so all the MPs are free to just walk in now?
Well, that's what the Standing Order requires, yeah.
Well, I mean, where do you think our unwritten constitution goes from here? Because, it would have all been very much simpler if the Constitution had said you can prorogue Parliament for 2 weeks or 3 weeks, or given it a time limit.
Well, I think the argument about a written constitution is a bit of a red herring. You can only have a written constitution if you can agree amongst yourselves what's going to go in it, and there's not much chance of that at the moment. So I think that is a red herring. I thought that this case showed that the unwritten constitution, the political constitution, was actually working. Much of the argument was about not what the government did, but what it might have done. And the fact is the government did only find that Parliament was removed for the period when it was expected to be removed anyway. I thought that showed a proportionate response to the fact that the court has held that a prorogation is not a proceeding in Parliament and cannot be challenged. What certainly is a proceeding in Parliament are the rulings of the Speaker. Now, in some ways, you can see that the government was reacting to the fact that his rulings might have been exploited in the time that was left. So instead of asking for a recess motion, which might have been exploited for other purposes, they produced the same effect with a prorogation. That didn't seem to me to be a disproportionate response. And the Speaker's rulings will not be challengeable.
Okay, so Stephen Laws, Alex Bailyn, both QCs, thank you very much for being with us.
Thank you.
Outside the Supreme Court on a really historic day in terms of British justice.